Then comes the stage of procedural steps. There are many directions that the parties have to follow. In many cases, parties agreed upon the directions that they may follow, but if they don't agree upon those directions, the court may give them the directions that they have to follow. There are some standard directions that are often adopted in small and fast tracks, but often in more complex multi-try cases, the directions are tailored to suit the needs of the case and are discussed at case management conferences. So, in the small and fast track cases, standard directions are mostly followed, but when there are multi-tracks and complex cases, the every case has been tailored or has to be tailored in a particular way that the directions should suit the case appropriately. So the first direction that has to be followed is the disclosure of documents. If the pre-action protocols have been followed, we have seen that pre-action protocols are the most important part of the civil litigation case. Because if pre-action protocols have been followed, then most of the work, pre-trial work has been done. Then the parties may have already had the early exchange of information and documentation. This puts a junction between the parties and opens the case for the both parties to fight the case in the best possible manner. That said, the disclosure of the documents is still ordered by the courts, and the parties need to consider what documents need to be disclosed to the other side and what documents can be inspected by the other side. So it is the court that decides what documents are to be disclosed and what kind of documents can be inspected by the party on the other side of the case. The disclosure and the inspection of documents is a crucial stage in the litigation process, as many of documents will have been written contemporaneously with the event in question. So documents are very important, disclosure and inspection of the documents, because some of the documents are made just for the litigation purpose, and so may be more reliable than to recall and memory or the memory of a witness. People may forget stuff, but documents are the stuff that remain the same over the period of the time. So in future we will look in some detail at the procedure involved in the disclosure and when a party might want assistance from the court to compel a party to disclose a relevant document before or during proceedings. Then comes the witness statements. It will hopefully make some logical sense to you that following the disclosure and inspection of documents, the parties should be in good position to finalize and serve their witness statements. After the disclosure of the documents, the parties come into the court and give their oral statements, which is called witness statements. So there are facts of the case, like something you claim that something has happened, and then you give your oral evidence to the case, and such oral evidence are the witness statement of the case. These written statements will serve as evidence of the facts that need to be proved. The witness may want to comment on some of the documents which they have seen, or it may be help the witness to clarify the version of the events. So the witnesses may come to the court and clarify about what documents, what type of documents deal with what kind of stuff, and opens the case in thorough manner. In civil proceedings, the parties should not be taken by surprise, and so one of the directions which will be given to the court will be a date by which any witness will need to be served. any witness statement will need to be served. If the witness statement is not served on the other side, then the evidence of the witness will not be able to be relied on at the trial unless the court gives permission. So the witness statements have not been served, so the evidence could not be relied of that witness because he has not clarified uh, about the evidence that he wants to give or has to give.